Hello, everyone. Welcome to our second Crescent Connections Lunchtime Knowledge Chat. I'm Lisa Crosta with Crescent Harbor Private Wealth, and today I'm joined with Anthony LaPorta from LaPorta Law. Anthony is a trust and estates litigator, and I'm going to let him do a little introduction for himself, but I do also want to say congratulations as Anthony has started his own firm literally this week. So he is a sole proprietor. That's the way, but I'll let Anthony talk briefly and just tell you about his background.
Thank you, Lisa, and it's a pleasure to be here. And yes, it's day 2 for my new firm. So yes, Anthony LaPorta. I am an attorney licensed in New York and New Jersey. Been practicing for more than 30 years, and my practice focuses on trust and estate litigation, trust and estate administration, guardianship proceedings, and mediation.
Excellent. So as a financial planner, I'm always talking to clients about get your financial house in order for when you're no longer here. Make sure you speak with a trust and estate attorney, get your documents together. But I thought it might be really helpful to speak to somebody who sees what happens when the clients don't follow that advice. Because Anthony deals with, as he said, litigation. So when there's problems, when maybe the documents weren't completed the way people thought. So we're going to start off, just have Anthony give us some best practices to maybe avoid ending up in litigation.
Okay, so there are a number of best practices. The first is that you should really adopt a team approach to your estate and financial planning. Not only should you be speaking with your trusted professionals, such as your wealth advisor, like Lisa, or your accountant, your insurance advisor, and your estate planning attorneys, you should have all of them communicate with each other so that they're working as a team in developing and implementing your estate and financial plan. So if your wealth advisor is making a right-hand turn, right, you want all of your other trusted professionals to be making the same turn as well.
Right. And I'll just add there, we see a lot where clients don't tell us that they set up a trust, so we can't move assets into the trust. So they end up paying for a lot of legal work, but they didn't actually fund the trust or retitle the assets. So a really great reason why I need to speak with the attorney so we get everything clear.
Another best practice is you should have an attorney who specializes in trust and estates prepare your estate plan. And the reason being, it's simple. It's essential that the plan that you create for transferring wealth is accurately conveyed, through your estate planning documents. If you have ambiguous language in a will or a trust, that can lead to litigation, and litigation costs can exponentially be greater than the cost to have your estate plan prepared. I can give you an example where a general practitioner who prepared wills as part of his practice, it wasn't his main focus. He prepared a will, and there was ambiguous language in that will, and we had to commence a lawsuit for the court to interpret what that meant. And it was a significant issue, and the legal fees exceeded over $100,000 for a will that cost less than $1,000 to prepare.
Yeah. Isn't that the expression, penny wise, pound foolish?
Correct.
And then I think we also talked about family meetings, right, Anthony?
We did. So the reason why you want to have a family meeting is so that you have a private meeting among your family members to explain the details of your estate plan so that there are no surprises when you pass. Disputes often arise, when a parent makes an unequal gift in his or her, to his or her children under a will. And while that is permitted in New Jersey, you're allowed to disinherit your family members. The affected child may certainly challenge your decision after you pass. And the typical challenges that we see to estate plans are that the parent did not have sufficient mental capacity to execute a will, or the parent was unduly influenced in preparing the estate plan. So during the family meeting, the parent can explain their plan for transferring wealth and the reasons behind it, and why there's going to be unequal gifting, which hopefully would reduce the likelihood for a future challenge.
And when we talked about this yesterday, Anthony, when we were prepping a little bit, it really reminded me, I have some clients that give children maybe money for a down payment. So the children get it at different times because they're different ages. They buy houses at different times. And I'm actually going to bring this up to a client because 2 of the children have gotten that down payment and the other 2 haven't. So is that in the will that those 2 children, and do they want it in the will? They're going to get additional money to make up for what was given in lifetime. And there's no right or wrong way, but what you said is having the meeting and having clarity so people understand if child 3 and 4 are getting an extra 100 grand, it's because the other 1 and 2 got it during lifetime. So it can really prevent disputes and make things clear, like you said.
Absolutely.
Yeah, it definitely gave me something to think about because it's not uncommon to see that. And then from a time standpoint, how frequently, Anthony, should people, review their documents?
So there's really no set rule, if you will, but you should be reviewing your estate plan, I would say every 5 years or earlier if there is a life-changing event. And life-changing events include marriages, the birth of a child, adoptions, a significant increase in wealth. So if you experience, a life-changing event, you want to make sure that your estate plan is consistent with your current situation and goals.
Right. Especially if you move states too. Is that a reason why people should, I assume, relook at their wills if they're changing their primary residence?
Yes, there's lots of different reasons for doing that. And from my perspective as a litigator, if you decide that you're going to if you're going to disinherit, let's say, a child from, in your will, and you do that, 20 years before you die, right? And every 5 years, right, you've looked at your will and you've reaffirmed it. You haven't made any changes. It's going to be difficult for that child after you pass to challenge that you didn't have the capacity or you were unduly influenced, right, to make that change.
Yeah, that's a good point. So then let's turn to those are best practices, some common mistakes that you see. I mean, there you'll have some overlap here. Power of attorney, living will. Do you see those frequently?
Sure, that's a big mistake that people don't have those documents, in their estate plan. So a power of attorney is a document in which you nominate someone to serve as your representative in the event that you're no longer capable of making financial decisions for yourself. And generally, an advance directive is a document in which you nominate someone to serve as your healthcare representative in the event that you are unable to make healthcare decisions for yourself. And if you don't have either of those documents and you lose the capacity to make financial and healthcare decisions for yourself, then a representative must be appointed by the court, and that involves a court proceeding. Typically, when I do a lot of guardianship work, so when there are disputes, it's typically not because a family member doesn't have capacity. Typically, capacity is not the issue. It's really who should serve as that person's representative. And I have seen siblings fight over who will control mom's assets and make decisions for her. And the costs are staggering. I've seen siblings incur tens of thousands of dollars each, fighting over who should be the representative. And of course, they all want the money to be paid out of the parent's estate.
Right, which just makes it smaller. And from the power of attorney and the living wills or healthcare proxies, I just try to remind clients that especially if there's only one surviving parent, to make sure they had contingents. So when usually they have each other, the adult, the parents, and they should have contingents because when one passes, they're not always going to remember to adjust it if their spouse is no longer here. So have contingents in there. So there's not a point where there's no one. That's some of our things we always remind people.
That's a good point. And that's the same thing when it comes to wills or trusts, right? You want to make sure that you've designated successors, or include a mechanism, by which a successor can be appointed. And I've seen this where a will only nominates a single person to be the executor, and then that person predeceases, right? So then there's essentially no one driving the bus, right? And if there's no one driving the bus, right, you now have to commence a court proceeding to have someone appointed.
Right. which costs money. And even if there's no arguments, you still have to go to court to find somebody, right? For the court to appoint that person.
That's correct.
Yeah.
Yeah.
Let's talk a little bit about trust. Clients always ask questions about, do I need a trust? Should I have a trust? There's so many different types of trusts, but I guess we'll just start with some of the things that you would like everyone to have, Anthony.
So, trusts they serve multiple purposes, and they are typically included for purposes of asset protection. But they provide protection against divorces, creditors, spendthrift beneficiaries. So, for example, if you have a child who is not financially responsible, you could direct that child's share of your estate to be placed into a trust, and then further direct the trustee as to how money is to be distributed to that child in the future. Right. And so you can have discretionary distributions for health, maintenance, education, and then you can also, set dates by when principal can be distributed. So you can set earmarks. So when the adult child reaches the age of 30, a certain amount can be paid out. When the person reaches 40 and 50, I mean, you can designate the time markers, if you will,
right,
for when principal is distributed.
Yeah, and I tell clients they can get pretty specific in there. I mean, as long as it's something you can put in language and is measurable, that you can dictate how you want the money to be paid out. And when you talked about, so just to clarify, if money's in a trust and that child has a divorce, that money's not going to be part of the divorce property, generally, if the trust is drafted properly.
Well,
also,
true. And
go ahead.
So, right. So in New Jersey, generally speaking, inheritance don't constitute marital property unless, of course, you commingle, right? So if it's in a trust and your child divorces, and the divorcing spouse typically cannot just simply say, okay, hand over half of the trust, right? And, I always use these types of examples. So if you don't have a trust, right, and let's say you have a child who is getting married, and unfortunately you pass before the marriage and your assets go outright to the child, right? You don't put it in trust. Well, child gets married and now has the inheritance, commingles it, and 6 months later there's a divorce, and now the divorcing spouse is walking away with half of the inheritance, right?
Right. And the liability thing, you told me a story the other day, Anthony, about the liability. So somebody had gotten an accident and killed someone, right?
Right. So that's the creditor protection.
Right.
So the example is that an adult child ran over a neurosurgeon in a crosswalk. Actually happened. And, if the parents had died and left everything to the child without a trust, right, just directly, the child would have had the inheritance, the accident would have happened, right? And, those are big judgments, right? So you can see where the inheritance is now going to satisfy those judgments. So that's one of the main reasons, for having trusts, right? In addition to divorce protection, creditor protection.
And like I said, the lawyers are always helping us think of these terrible situations that we have to plan for, but that is your job.
Yes.
And I see this a lot, having multiple executors or trustees or whatever else. And so tell me about some of the stuff that you see when you see multiple names.
So it's a significant issue, and I think people don't realize it, and they often don't want to choose between, their children as who should serve. The typical example, right, is, mom, surviving spouse, she has 2 kids and she can't decide, so she nominates both of them to serve as the executors under her will. And then she dies. And now the 2 adult children, assuming they both qualify and they're now serving as executors, they're obligated to work together, right, to administer the estate. But what happens if they don't get along, right? And if there's an impasse over an issue in administering the estate, then each adult child as executor typically retains an attorney, and then they file a court proceeding. And during that time, the administration of the estate can stall. I've seen, and this happens often, I've seen where you have the two executors come in, they're fighting, and the court will say, well, we can't just have the administration of the estate stay on hold. We're going to appoint a temporary. So they're going to appoint a neutral person to come in
Oh,
and administer
interesting.
the estate, and then let the siblings, fight over it, in court as to who ultimately would be appointed. So, if there's ways to resolve it, if you have carefully crafted language in a will that addresses how to resolve disputes among multiple executors, that may solve the issue. But often the better approach is to nominate an independent corporate trustee. They will serve, without compassion, right, without emotion. And then you take that issue completely off the table for
Right,
your children.
right. And you've definitely seen circumstances where, you end up wasting so much money. And I want to say wasting because it's your business, Anthony, spending a
Yeah.
lot of money that was supposed to go as an inheritance.
Yeah.
The other thing that you brought up that I wasn't familiar with was a funeral agent, failing to designate a funeral agent as a mistake people make.
Correct. So ordinarily, when one of two spouses die, right, the surviving spouse makes the final arrangements for the deceased spouse. But what happens if you're widowed or you're divorced and you have two children who you nominate, as the executors under your will? And what happens if they don't get along? So I have seen adult children hold separate services for a deceased parent because they could not agree on the arrangements. And
That is
so to
insane.
avoid, right, and it doesn't go well. Sometimes they end up showing up at the others the other services, and it's not a good scene. So to avoid that situation, you can designate a person to serve as your funeral agent in your will or on a form that is approved by the New Jersey Cemetery Board. And that person is then in charge of making the final arrangements after you die. And it doesn't have to be one of the executors. It can be a completely independent person, or it can
Yeah.
be just one of the two executors, but you're just going to nominate one person.
And you can leave a lot of your instruction, right, with that letter. Like you can clarify, how you want the service, what music, the whole shebang, right?
Sure. And you could also do prepaid funeral
Right,
arrangements as well.
right.
But yes, that's correct.
Um, Guardians. This is something that I always try to push my clients with younger kids to take care of. And I had a client for a while that was taking a long time to do this because they couldn't decide who to make as the guardian for their three minor children. And what did finally get them moving is I said, you guys have made a decision by not making a decision. You just decided that the court's going to do it. And that sort of piqued their interest. And they did finally get it done. So what do you see if there's no guardian in a will and there's minor children?
So if the parents do not nominate a person to serve as the guardian, then um, assuming the parents die while the child is a minor, then family members have to step up, and then someone will have to commence, a court proceeding to be appointed as the guardian. And sometimes you have, family members on both sides, from the husband's side and from the wife's side, say, well, no, I think I'm better suited to serve. And then it becomes a fight and a contest, right? And, contests and guardianships can become very expensive.
Right, right. Let's talk a little bit about like valuable property, artwork, jewelry. That's sometimes something that you see a lot of people argue about. Mom said I could have this painting or this ring, and so what do you do to kind of smooth that part over?
So we see it all the time. And, when one of the adult children says, yeah, well, mom wanted me to have this. Well, if it's not in the will, then there's no indication that that's the case, right?
Right.
So you can create what's called a tangible property memorandum. It's a written list, and it's identified in the will, and you can write out, who you want to receive certain items. So you can list all of your jewelry and identify who gets what piece. That's one way to do it. You know, leaving it up to the executors to make that decision, that's common. But there's always fighting. There's can always be fighting among the surviving children as to who gets what. It's extremely important that if you during your lifetime give a valuable item to, let's say, one of your three children, right? It's very important to let everybody know what you did, right? Because I've seen what happens if you don't. I've seen that after the parent dies, the other siblings, find the other adult children find out that their sibling has an expensive painting or mom's, diamond ring. And they say, well, how did you get that? Right. And the response is, well, mom gave it to me. Well, if they're hearing about it for the first time, typically they will challenge it and they will argue that it was taken without permission and has to be returned to the estate. And then, that involves litigation. And, it's he said, she said at that point in time, right? So the court then has to make a decision as to, who's more credible.
So if somebody wants to give something valuable during lifetime to one child, do you recommend that they write it down and that they did do this? And, because it's not part of their will anymore, right? Because they did it during lifetime. So how do you prevent people from coming back afterwards to say, mom didn't really give it to you?
Yeah, there's certain ways to do that.
Yeah.
Having the sit down, mom tells everyone, look, I'm giving this item to, to this one child, right?
Right.
You could, if you really want to create a paper trail, because I always say, paper trail, paper trail, paper trail, because that's all evidence, in litigation speak, right?
Yeah.
Have mom write a letter, right? She signs it, and it's to everyone saying, I'm giving this, I have given this gift to, Sarah, so everybody is on board and they all understand what took place.
Right. Right. It is tricky, these lifetime stuff versus afterwards, and people trying to make up for it.
Yeah, and these are families, right? I mean, you
Right.
don't necessarily thinking about what's going to happen, and there's going to be disputes, but unfortunately, I'm always thinking about the disputes and the litigation. So,
Right.
yeah.
Right. And I do find that with the attorneys, they're thinking of things that we don't think of to prevent, because they've seen it before, to prevent the arguments afterwards. Beneficiary designations. I mean, we touched on this with the will, with, having a contingent beneficiary. I talk about this a lot when I do my presentations, that the retirement type assets will have direct beneficiaries on them. Make sure they reflect your wishes, because they will follow. They don't go through the will, right? They go through the direct beneficiaries, the 401ks, the 403bs, the IRAs. Life insurance. I'm trying to think what else is on there. And just to keep them correct and have contingents, right? So if you had a spouse and spouses had each other, have the contingents as the kids, if that's what you want.
Correct. And you want to make sure that you're following through with making beneficiary designations. So for example, if your estate plan contemplates that you are going to designate a trust that you have created, right, as a beneficiary under a life insurance policy,
right,
but you fail to follow through and make that designation, right, then the death benefit proceeds are not going to go to the trust, after your death. So you have then failed to fulfill, an element of your estate plan. Right. And I see that happen quite often.
Which goes back to the community. One of the things we first started with, the communication between all the different advisors. And I have definitely had clients come to me and say, I think I formed this trust, but I never did anything with it. I'm like, well, what do you mean? Did you? Then they're like, oh, I think this trust is supposed to be the beneficiary of my stuff. I'm like, well, we got to do that. Like, you can't just tell me. It's paperwork. You got to fill it out. And unfunded trusts, as we call them a lot, it happens. And the clients spend money to do it, but it's that follow through step that is sometimes forgotten. They forget to tell me. Some of the things when we do planning, we try to remind them, look at your beneficiaries. Did you talk to an attorney? Let's get everything all buttoned up.
Yeah, I'll give you a quick example on
Yeah.
that. So I had a case a long time ago where the husband prepared a trust, and he kind of did it himself. It was one of those do-it-yourself
Do it yourself
estate
trust.
plans. Yeah.
Interesting.
So creates a trust and, you know, names. Then he has an insurance policy, purchase insurance policy.
Hmm.
And the idea was he was going to name the trust as the beneficiary of the life insurance policy, which is typical, right?
Right.
But he had named his wife in the insurance policy, and then failed to make the change, right? And at the time that he died, his wife had already lost capacity.
Oh.
So, and she didn't have healthcare directive, didn't have power of attorney. So he dies, and now the life insurance policies goes to the wife, but she can't change it because,
Oh,
right,
wow.
she did not designate someone as under a power of attorney to act as a representative.
Oh,
So she
man.
couldn't make the change, and therefore his estate plan failed.
Huh. So what do you do in that case? Does somebody go to court to get
So
guardianship kind of thing, or conservative, whatever
yes,
it's called?
yes, that's correct. Right. And then that incurred legal fees.
Yes, of course.
Yep.
Yeah, there's a lot of forgetting. I mean, I've heard stories of people, leaving their ex-spouses on things and or two or their three kids, and they're like, "Oh, the will takes care of all of it," and they forget that there's other accounts out there, like the retirement accounts and the life insurance that have other people on them. So it's important to look at everything, all as one big plan. Um, let's see. We'll touch on maybe just one more tip. Um, I'm just looking at some of the ones we talked about that are the most interesting.
Well,
Um,
I
yeah, go
think the
ahead.
one that we talked about is the end of life changes to your estate plan,
Yes, yes.
right? And, I have seen where, um, let's say dad is the surviving spouse.
Okay.
He's in the hospital and he's on his deathbed. And I have seen where he calls attorney to come into the hospital and sit next to him and dictate out a will and leave everything not to his children from his first marriage, but to a girlfriend, right? And so these are the end of life changes, and they're not always that significant,
Right.
right? But even if you just disinherit a child late in life, within a few years of death, you're inviting a will challenge, right? Because typically the person who's affected is going to say, wait a minute, this doesn't sound right. Dad would never have done this. Dad could not have had the sufficient mental capacity to do that, to create a will and to decide to disinherit me. And quite frankly, he was probably pressured by either my siblings or the
Right.
girlfriend, right?
Right.
In either situation. So when you're making those types of changes and you do it close to death, like end of life, you're buying a will challenge for your heirs,
For sure.
essentially.
For sure.
Yeah.
So I wanted to keep it to about 30 minutes, but I will open it up. I don't know if there's any questions in the chat at all. I'm just trying to see. If anybody is listening, wanted to pipe up with a question or write it in the chat, we'll just give you a minute. I think the moral of the story is do your paperwork, check it frequently, not frequently, but check it routinely, and be clear. Lack of communication causes, I would assume, a lot of problems. Be clear to your family what you plan to do and make sure your paperwork represents it. And there's contingencies set up for whatever there can be.
Exactly.
That's my words of wisdom. Do you have anything to add, Anthony?
No, you nailed it.
Okay. Well, I'm going to let everyone go. And I also, again, want to say congratulations on going out on your own, Anthony, yesterday. It's great
Thank you.
news.
Thank you.
And I think that we'll finish it there.